much should I take out of our joint accounts before divorce? Hi, I'm Bill Farias, founder of Farias Family Law, and this question just came up a couple of days ago. I met with a client who has a significant amount of money in some joint accounts, and he very much wants to protect that. He's afraid that his wife is going to wipe out the joint accounts. And so the question came up, how much should I take out? The best way to approach this is to first of all recognize that there is no black and white answer to this. And the reason for that is that there are a number of factors that will ultimately dictate whether removing money from the joint account is a good idea, and if so, how much. So for example, you have to think about how long is this marriage. If it is a short marriage and one party put a significant amount into that joint account before the marriage, then it could be that the party who put that money in is going to get a substantial credit on that joint account. In other words, it could even be that the judge says, hey, I'm not going to divide that premarital money. Another factor to consider is what the prospects are that the parties are going to operate reasonably and work together, because in that case, if you have two people who are reasonable, who are going to work together, and you have one party going in and swiping a bunch of money from the joint account, that might cause a lot of unnecessary friction. And so in those circumstances, it could be that wiping out that money or withdrawing that money was not necessary, because the person on the other side was going to be reasonable and was going to cooperate and was going to commit to getting the case resolved amicably. And so what you might do in that situation, if you go in and you swipe a bunch of money unnecessarily, is now you're causing friction. You're causing chaos. You are breaching trust. And that may ultimately result in you having to spend more money on your divorce. However, in certain circumstances, it does make sense to go in and to take some money to protect yourself. Because what might happen is the other party might go in and take most, if not all of it. And so in certain circumstances, it makes sense to be proactive and to go in and take a fair amount for yourself. Now, what that fair amount is and how much you should take really depends on the specific circumstances of your case. A lot of attorneys use a rule of thumb of half. So it's very common for attorneys to tell people moving toward divorce, hey, you can go into the joint account and just grab half of that money and put it into your individual account. And that's not necessarily wrong. In many cases, it is the fair thing to do. However, you also have the issue of potential credits, and those credits should be factored in to how that money gets divided. And so the only way to know for, not for sure, but with some degree of confidence what the correct amount is to take from a joint account is to sit down first and talk to an attorney about the finances. If you talk to an attorney who's reasonable and reliable, that attorney can give you a number that makes sense for you to grab from that joint account to protect yourself. If you have any other questions, you can call us at 508-675-0464. You can email us at info@fariasfamilylaw.com. If you found this video helpful, you can subscribe to our channel and share it with anyone you think might benefit from it. And you can also find us on social at Farias Family Law. Thank you. Have a good day.